Can a promoter's cousin become an independent director? Has SEBI just changed the way we understand board independence? Is a family connection enough to disqualify a person from becoming an independent director? What happens when the Companies Act says one thing, but corporate governance expectations suggest something else? Regulation 16(1)(b) of SEBI LODR. Who can be an independent director? One of the most important pillars of corporate governance in a listed company is the presence of independent directors. SEBI believes that shareholders' interests can be protected only when the board contains directors who are independent from promoters, management, and controlling shareholders. For this reason, Regulation 16(1)(b) of SEBI Listing Obligations and Disclosure Requirements Regulations 2015 prescribes detailed eligibility conditions for independent directors. An independent director should not only be independent in name but must also be independent in thought, judgment, decision-making, and conduct. Let us understand each clause in simple language. Welcome to Corporate and Securities Law Compass, navigating law with clarity. Today we are discussing one of the most interesting corporate governance questions that has recently come before SEBI. The issue appears simple. At first glance. Can the cousin of a promoter group member be appointed as an independent director of a listed company? But once we start reading Regulation 16 of the SEBI listing regulations, the Companies Act 2013, and SEBI's Informal Guidance Letter, the issue becomes a fascinating lesson in corporate governance, legal interpretation, and board independence. This matter arose when Maithan Alloys Limited approached SEBI under the SEBI Informal Guidance Scheme 2025 seeking clarification on Regulation 16(1)(b)(3) of the SEBI listing regulations. Before we discuss SEBI's answer, let us understand why independent directors are so important. An independent director is often described as the guardian of minority shareholders. Independent directors are expected to bring objectivity to board deliberations. They are expected to challenge management decisions when required. They are expected to protect investor interests. They are expected to review related party transactions. They are expected to monitor governance standards. Most importantly, they are expected to exercise independent judgment. That is why SEBI imposes strict conditions regarding who can and cannot become an independent director. Let us first read the law. Regulation 16(1)(b) of the SEBI listing regulations defines an independent director. The provision states that an independent director means a non-executive director who satisfies various conditions relating to integrity, independence, financial relationships, employment relationships, shareholding, and other governance requirements. One of the most important provisions is Regulation 16(1)(b)(3). This clause states, an independent director should not be related to promoters or directors in the listed entity, its holding company, subsidiary company, or associate company. At first glance, the provision appears straightforward. But then a practical question arises. What exactly does the word related mean? Does it include spouse, children, parents, brothers, sisters, cousins, second cousins, extended family members? Or should the term be restricted only to persons falling within the legal definition of relative? This is precisely the issue that reached SEBI. Let us understand the facts. The promoter of Maithan Alloys Limited was Mr. Subhash Chandra Agarwala. Among the promoter group members was Mr. Siddhartha Shankar Agarwala. Mr. Siddhartha Agarwala was not merely a promoter group member. He was also a director in two subsidiary companies of the listed entity. The company identified a highly qualified candidate for appointment as independent director. According to the application, she possessed a doctorate degree. She was associated with academic institutions. She had management qualifications from premier institutes. She had published research papers. She possessed substantial professional credentials. However, there was one issue. The proposed candidate happened to be the daughter of Mr. Siddhartha Agarwala's father's sister. In simple language, she was his cousin. The company therefore approached SEBI and asked, "Can this cousin be appointed as an independent director? Or does Regulation 16(1)(b)(3) prohibit such appointment?" Now let us understand the company's argument. The company relied upon the legal definition of relative. Section 277 of the Companies Act 2013 defines the term relative. This definition is further supplemented by Rule 4 of the Company's Specification of Definitions Details Rules 2014. Under these provisions, certain family relationships are specifically recognized. These generally include father, mother, son, daughter, brother, sister spouse, and certain specified relationships through marriage. However, cousins do not form part of the statutory definition. This became the foundation of the company's argument. The company argued that since cousins are not included within the legal definition of relative, a cousin should not automatically be considered related for the purpose of Regulation 16(1)(b)(3). The company therefore took the view that the proposed candidate remained eligible for appointment as an independent director. Now let us understand SEBI's analysis. SEBI first noted that Regulation 16(1)(b)(3) requires that an independent director should not be related to promoters or directors. SEBI then examined the relationship. The guidance letter specifically records that the proposed candidate was the daughter of Mr. Siddhartha Agarwala's father's sister. SEBI then examined whether such a cousin falls within the legal definition of relative. After reviewing Section 277 of the Companies Act, Rule 4 of the Company's Specification of Definitions Details Rules 2014 and Regulation 21ZD of the LODR regulations, SEBI observed that a cousin is not identified as a relative under these provisions. This became the turning point. SEBI concluded that based on the facts presented, the cousin may be eligible to be appointed as an independent director of the company. Now, this is where many viewers make a mistake. They assume SEBI has given a blanket approval. That is not correct. SEBI specifically added an important caveat. SEBI reminded a company that every other condition prescribed under Regulation 16(1)(b) must also be satisfied. In other words, merely because the cousin relationship is not disqualifying does not automatically make the person eligible. Let us understand these additional conditions through practical examples. Suppose the proposed independent director's husband owns 5% shares of the company. That may violate the shareholding conditions. Suppose the proposed independent director's consulting firm receives substantial fees from the company. That may violate the pecuniary relationship test. Suppose the proposed independent director was CFO of the company 2 years ago. That may violate the cooling off period requirement. Suppose the proposed independent director's relative has guaranteed a large loan of the company. That may affect independence. Therefore, appointment cannot be examined solely on the cousin relationship. The entire framework of Regulation 16 must be satisfied. Now let us discuss the governance lesson. The legal answer and governance answer are not always identical. Legally, SEBI observed that a cousin is not a relative under the relevant provisions and may therefore be eligible. But from a governance perspective, the board must still ask, will investors perceive this person as independent? Will minority shareholders have confidence in the person's objectivity? Can the person genuinely challenge promoter decisions when necessary? Can the person independently review related party transactions? Can the person objectively evaluate management performance? These are practical governance questions. Corporate governance today is no longer limited to technical compliance. Good governance requires both legal compliance and stakeholder confidence. For nomination and remuneration committees, this guidance letter provides valuable lessons. Before recommending an independent director, the NRC should examine professional qualifications, family relationships, promoter connections, past employment, business relationships, consulting arrangements, financial interests, potential conflicts of interest. For company secretaries, this case highlights the importance of conducting detailed due diligence before placing any appointment proposal before the board or shareholders. For promoters and directors, this case demonstrates that independence should not merely exist on paper. It should also be visible in practice. For investors, this case shows how SEBI carefully balances strict legal interpretation with broader governance objectives. The most important takeaway from this guidance letter is that independence is a principle, not merely a designation. An independent director is expected to be independent in law, in conduct, in judgment, in thinking, and in the eyes of investors. That is the true spirit of Regulation 16 of the SEBI listing regulations. And that is why this seemingly simple question about a cousin becoming an independent director has become one of the most interesting corporate governance case studies in recent times. Thank you for joining us on Corporate and Securities Law Compass, navigating law with clarity.